Okay, chapter 14 looks at forensic psychology and how it can be used in the workplace. So, psychologists can provide help in the workplace in the following areas: job analyses, the selection and hiring of employees, development and implementation of training programs, leadership and job satisfaction studies, and promoting job satisfaction and favorable working conditions. Now, they're also involved in terms of things like sexual harassment and consultations with management. So, distributive justice refers to how available rewards are distributed or divided up among members of a group or a society, or the relationship between contributions that people make and what they get back. And in the US, this is mostly based on equity. When we're thinking about this, we're thinking about the rewards people receive and how they ought to be distributed in proportion to each person's contribution. Now, there's no single method for determining the value of different contributions and fair allocations of rewards. Courts have considered if educational qualifications adversely affect employment opportunities of minority applicants, whether gender issues such as dress and appearance codes impact that. They've also looked at affirmative action issues and whether English only policies result in national origin discrimination. Employment discrimination generally deals with race, sex, age, religion, disability, national origin, and sexual orientation. And we have several sources of federal law that serve as a guide for this. So, Title VII, the ADEA, the Age Discrimination Employment Act, the Equal Pay Act, and the Civil Rights Act of 1866, 1871, and 1991. So, Title VII of the Civil Rights Act prohibits someone from discriminating against an individual on the basis of race, color, sex, national origin, or religion. And this is in regards to hiring, discharge, compensation, promotion, classification, training, apprenticeship, referral for employment, or any other terms, conditions, and privileges of employment. So some cases have looked at things like derogatory racial and ethnic slurs. So in DiCarolo versus Potter, the supervisor had called their employee a dirty wop. In Belliver v. Quanex, the employer disapproved of female employees' aggressive and sometimes abrasive interpersonal skills while tolerating that in male employees. And so the jury concluded she was terminated for not behaving in the way her employer deemed appropriate for females. In Frank v. United Airlines, flight attendants' maximum weight was being judged from the medium body frame category, while male attendants' weight was being judged from the large frame category. And the court held that this was not a justified, bona fide occupational qualification. In Olson v. Marriott, the hotel had rejected a male massage therapist, stating customers preferred female massage therapists. Again, not a bona fide qualification. In Griggs v. Duke Power Company, there were people applying for manual labor jobs, and the employer had required that they have a high school diploma. This resulted in a large number of black applicants being excluded, and again, this was found to not be validly related to the duties of the job. And in the Nichols case, the Ninth Circuit held that a male employee who was repeatedly teased for female mannerisms and referred to as she had a viable cause for action. And in this case, this was severe and pervasive hostile work environment, and that was the result of gender stereotypes. So the ADA is enacted in 1990, and it prohibits private and public employers from discriminating against people with physical or mental disabilities. And this is enforced by the Equal Employment Opportunity Commission and the Department of Justice. And it does require employers to make reasonable accommodations. So in the Carragher v. Rent-A-Center case, this was requiring anyone seeking promotion to take the APT Management Training Executive Profile. And this was looking at math, language skills, personality traits to determine if someone was suited for promotion within a fast-paced office setting. But part of this included the MMPI, which we talked about in a prior chapter. And that's a clinical test that can reveal confidential and diagnostic formulations, personality disorders, and other mental health issues. Now, while those results were never evaluated by a psychologist, it was an inappropriate and invasive medical examination. Now, in Petzl v. Bormans, Inc., Petzl had suffered from Tourette syndrome and was working as a bagger at a grocery store. Supervisor informed him that his outbursts could not be tolerated, and he sued for discrimination and initially won. The employer appealed, and the appellate court found that his offensive language did make him unfit for a job as a bagger, and it also constituted misconduct under the employer's work rules. Now, the Age Discrimination in Employment Act prohibits discrimination on the basis of age against employees 40 and older. And in the Jack in the Box case, a 52-year-old employee sued for age discrimination, and he was able to show a prima facie case of age discrimination because the supervisor repeatedly made ageist comments. In Western Airlines, they refused to allow flight captains 60 and older to switch to the position of flight engineer. Flight engineers were required to retire at the age of 60. Again, this was not seen as a bona fide occupational qualification. It did not do anything to reasonably ensure safe transport of passengers. Now, the Equal Pay Act prohibits wage discrimination for equal work on jobs that require equal skill, effort, and responsibility and are performed under similar working conditions. Now, in EEOC versus Outback Steakhouse, a male counterpart was being paid a significantly larger salary. When a female employee complained, she was fired. In the Marist College case, there was an assistant professor there, and she was denied tenure, but was promoted to associate professor 3 years later. She never received full professorship and was paid less than her male colleagues. She filed to have her salary reviewed for gender parity, but the college president determined she was fairly paid. She won $118,000 in attorney's fees and back pay when a jury agreed that women were generally paid less than men in comparable positions. Now, in this next case, an employee asked to be paid on a flat scale when he learned that his pay of $30,000 was much less than another employee who was earning $52,000. Now, the reason he thought that for this difference was that he was Hispanic. But both the district and appellate courts agreed with the employer that the employer did so based on work output, which was a legitimate reason. So what are the ways in which psychology can contribute? Well, individuals can sue a state agency for money damages, and people with disabilities do have federal recourse against state employment discrimination under Title I of the ADEA. Now, what are some ways we see this playing out? Well, we see negative stereotyping, and that's the belief that people that belong to a particular group are subject to disability-related discrimination. They share certain negative traits, and the mere fact of having a disability is believed by some to generalize to that person's potential and limitations in areas that extend far beyond the disability itself. Whereas stigmatization is distrust, fear, embarrassment, and even avoidance of persons with mental disabilities. This tends to deny them access to resources and opportunities and is often psychologically harmful and can lead to low self-esteem, isolation, and loss of dignity. Now, psychological discomfort is feelings of disgust or repugnance that some people experience when interacting with or being in the proximity of persons with disabilities. Closely linked to this is also paternalism and pity. Society might express profound and sincere sympathy towards certain groups while at the same time subordinating them. Now, we also want to remember that discrimination can be overt, subtle, or covert. Now, overt is very readily apparent and easily documented. We see this in harassment, language and jokes, and even physical violence. Subtle discrimination is unequal and harmful treatment of people that may be visible but often isn't noticed because it's often seen as custom or tradition. Covert is harmful treatment of members of certain groups that is hidden and difficult to prove. As a result, it may last longer and be more resistant to change. Now, sexual harassment generally has two types: quid pro quo, where employment is made contingent upon complying with sexual demands, and hostile work environment, where remarks, insults, or intimidation create an abusive atmosphere and make the work environment intolerable. And in the U.S., sexual harassment is illegal under anti-discrimination laws. And we can see here a timeline of some rulings and precedents in regard to sexual harassment. So in the 70s, we see quid pro quo is deemed discrimination and constitutes sexual discrimination in education. Any retaliation after rejection of sexual advances by your boss is also a violation of Title IX. Title VII. This should say 1980. sets the legal precedent for hostile environments. Also in the 80s, we see that definition is upheld and holds employers liable for sexual insults and propositions, even if the worker did not lose any job benefits as a result. Physical violence can also be sexual harassment if the conduct is based on the victim's gender. And a hostile work environment is a form of sex discrimination under Title VII. It does not need to lead to economic or tangible harassment, but the severity and pervasiveness of the environment must be proven both subjectively and objectively. Now, in the 90s, we see the Civil Rights Act of 1991, which strengthens the prior Civil Rights Act and provides for increased damages in cases of intentional employment discrimination. During this time period, we also see a change in the analysis from the reasonable person to the reasonable woman standard. Also during the 90s, we see that conduct doesn't have to seriously affect an employee's psychological well-being or lead them to suffer injury to be actionable. Here we want to look at the totality of the circumstances. Employers are also vicariously liable for actionable discrimination caused by a supervisor, and an employee who refuses the unwelcome and threatening sexual advances of a supervisor, yet suffers no adverse tangible job consequences, can also recover against the employer. And then finally, sex discrimination consisting of same-sex harassment is also actionable because Title VII is meant to protect both men and women. In this particular case, the plaintiff was forcibly subjected to sex-related humiliating actions and threatened with rape, and she felt that if she did not leave her job, she would be raped. Now, how pervasive is sexual harassment? A survey of federal government employees found 42% of female workers had experienced at least one incident in the previous year. A 1993 study found that half of working women have experienced sexual harassment. 40% of women in large law firms report being touched inappropriately, called honey, and being sexually harassed, and 65% of women in the Marine Corps. Now, only 5 to 15% make formal reports. These victims are often fearful of losing their job, not being believed, believing nothing will be done, and they often feel embarrassment and shame. Those that do file often face a legal process where the details of their lives will be publicized in court. Now, with Title VII, Congress did intend to strike at the entire spectrum of disparate treatment. We see that this is upheld in terms of pregnancy discrimination, that particular piece of legislation also applies to male spouses of pregnant women, and that the objective severity of harassment should be judged from the perspective of a reasonable person considering all circumstances. Now, what about personality traits that might relate to harassers? Well, there's two types of sexual harassment: benevolent male sexual harassment and hostile male sexual harassment. The benevolent type is characterized by a genuine desire for lasting heterosexual intimacy. And the motives for this include protectiveness, favorable attitudes towards women in traditional roles, and a desire for intimacy. Whereas hostile male sexual harassment is about male dominance. This is often done by men who believe in male superiority, view women as inferior, and maintain a desire to dominate women sexually. Some research also connects harassment with authoritarianism. This is a rigid adherence to cultural traditions and traditional gender roles. It's often self-righteous, vindictive, envious attitudes, and these men often see the world as a dangerous place. In terms of hypermasculinity, we often see some excessive and rigid over-identification with stereotypical male role models. So, what is the impact of sexual harassment? This obviously has serious negative effects: anxiety, depression, sleep issues, weight loss or gain, loss of appetite, and headaches. When this harassment continues for a long period of time, we see some victims develop PTSD symptoms. We see increased alcohol consumption as well. So, forensic psychologists can offer expert testimony to explain these reactions. Why do victims remain silent? And what are the reasons for that? Now, remember that claims are based on the reasonable woman standard. So a common defense here would be to say that the woman who was alleged sexual harassment here is not reasonable. Now, in Ramirez v. Kelly, There was an ongoing voluntary sexual relationship, and when she discovered that he was married, she sued for sexual harassment, claiming she was raped and coerced to carry on the relationship. But the defense presented evidence that she suffered from borderline personality disorder. And in a 1994 case, the plaintiff complained of being persistently picked on by supervisors and coworkers, but experts testified that she had a paranoid personality disorder. Now, forensic psychologists can also play a role in mediation, and this is intervention into a dispute or a negotiation of an acceptable, impartial, neutral third party who has no decision-making authority. And this is particularly useful in highly polarized disputes. Now, in terms of workplace violence, over 2 million workers are victims of violent crime each year. And you can see here that 18% of all violent crime takes place at the workplace. Now, police, corrections officers, cab drivers, private security workers, and bartenders are the ones that are most likely to be victims of duty-related violence. And we have 5 categories of people who commit workplace violence. Now, many of these we've talked about in prior chapters, so we're going to focus on just 2. First, let's look at the resentful and disgruntled employee. They're usually in their 30s or 40s and about to be fired or laid off. Now, a middle-aged man, if he's about to find himself unemployed, may have a strong connection to his job. And this may be followed by depression, low self-esteem, alcohol abuse, and a desire to get even. And it's often not so much that the layoff happened, but that it happened in a dehumanizing manner. These killers identify strongly with their job. They may be loners with a few outside interests or friends. They often file grievances and are chronic complainers, have difficulty accepting authority, and may threaten violence directly or in a veiled manner. Warning signs include difficulty accepting criticism, brooding over recent humiliating life events, poor interpersonal skills, a history of violence, impulsivity, or making threats, a tendency to raise their voice, intimidate, or lose temper, and a history of domestic violence, legal difficulties, conflict with coworkers, and making unwelcome sexual advances. Now, we also have stalker types. Now, stalking is sometimes called love obsession or romantic stalking, and usually involves a spurned ex-lover or spouse whose primary motivation is revenge, or a severely disturbed individual who experiences unrealistic fantasies, or even a delusional disorder where he believes the victim is in love with him. And the erotomanic type is a stalker who engages in continuing efforts to contact the object of their affection. Clinically, these cases tend to be females, but when these cases come to the attention of the criminal justice system, they tend to involve men. The offender often fits either dependent personality disorder or borderline personality disorder. Now, what kind of role does personality differences play? So there's 2 concepts related to anger. One is state anger, and that's an emotional response to a particular event, and it's generally temporary. And then there's trait anger, and this is your disposition to experience anger over time and across contexts, and it's generally a stable personality trait. Those that are high in trait anger are likely to respond aggressively to situations. They see a wider range of situations as anger-provoking. Their anger is of greater intensity and lasts longer, and it's more likely that they'll respond violently. Those who view aggressive behavior as acceptable are more likely to engage in it, and those who engage in aggression for revenge often view their behavior as acceptable and justifiable. Negative affectivity refers to a general disposition towards subjective stress. Those that are high in this perceive themselves as in distress. They're very sensitive to negative events and have a generally pessimistic view. This seems to be a positive relationship between this and depressing affectivity and the projection of negative and hostile motives to the workplace. So this can also lead to aggression in the workplace. Now, self-control. Those that are lower in self-control are likely to engage in aggressive responses to provocative situations. Now, also those whose a person's cognitive appraisal of negative outcomes can also predict anger and subsequent aggression. So basically, How you judge who is at fault or causality can increase the likelihood of aggression. So those who attribute negative workplace outcomes to others and believe those outcomes were controllable, aggression is more likely. Now, whenever there's a lingering threat of violence, there can be a decrease in morale and productivity. And if your employees lose confidence in the ability of your organization to protect them, they may start to look for other jobs. Liability can be imposed in legal claims made under a theory of negligence, basically that the employer knew or should have known. Now, in Carr v. William Crowell, the employer was held responsible for an employee's intentional action of attacking another employee with a hammer, and the court said the injury was a result of the workplace setting. In Vining v. Avis Rent-A-Car, there was a $750,000 award for the failure to check the background of an employee who raped a coworker. The applicant had served 3 years for a robbery. In Maloney, there was a $4 million judgment to a woman who was raped by an employee, and the court ruled that the company had a general duty to check the criminal record of employees interacting with the public. In Smith v. Amtrak, there was a $3.5 million judgment for failure to discipline an employee for prior violent actions, who then later shot and seriously wounded his supervisor because, of course, in this case, the violence was foreseeable. Now, again, what contributions can psychologists make? They can help with effective pre-employment screening, developing policies and procedures on how to deal with threats, implementing risk reduction programs and therapeutic interventions, and crisis management. So in terms of pre-employment screening, we talked about this quite a bit in the chapter on law enforcement, but before making an offer, we should do a thorough background check on employees. Any psychological test that is used must be reliable, valid, and useful. So to be reliable, it means that the test yields the same result when administered at different times. To be valid, it needs to measure what it says it measures, and its utility has to do with how useful it is. So areas of assessment often include intelligence and problem solving, honesty and integrity. But keep in mind that any regimen must not have an adverse impact on any race, sex, or ethnic group. In terms of developing policies and procedures, all employers should develop a formal workplace violence program, and they should train employees at all levels to basically recognize and report danger signs. It's helpful to have policies on when to recommend discipline, voluntary therapy, mandatory medical leave, psych evals, and mandatory drug testing. And it's also important to provide both instrumental and informational support. Informational support is just the training on how to deal with a particular situation, whereas instrumental support is what we think of when we think of support. It's that support that we receive from our coworkers and supervisors after an act of aggression or violence. Both of these types of support mediate the effects of workplace violence. We should treat each worker like an adult worthy of respect and focus on problems to be solved and the responsibility for solving that problem. If we have a potentially violent employee, a plan should be developed to reduce the risk. Now, when we're looking at the risk they pose, we're looking at static factors, things that do not change, and dynamic factors, things that do change, like our stress level. We also want to assess their history of alcohol and drug use, their weapons history, and we also want to make sure we have a policy in place for any necessary tariff-off warnings. And finally, crisis management. Every place of employment should have a crisis management team. It should include a member of the executive management, from HR, security, and risk management, a legal advisor, a psychologist, and an employee representative. This group should be the ones developing workplace violence policies and should be the decision-making body when workplace violence issues arrive. They should report directly to the highest ranking executive officer in an organization and should have a working knowledge of the organization and be experienced experts in their discipline.